if you're unfamiliar with the Oregon Law Commission. Mark Comstock, who is our chair, will be leading the meeting, and he'll be the next person to speak. If you are using the computer platform, I'm going to keep everyone muted unless you want to speak. If you're on the computer platform, simply just click your unmute to speak. If you're on a phone with a mute feature, you can do that. If you're on a phone, like a desk phone that does not have a mute button, you can use the *6 to mute and *6 to unmute as well if you want to speak. So thank you all for joining us. Also, just if you're an interested party or new to this, Oregon Law Commission meetings are recorded for public record and will be available to review at a later date. So I'm going to turn it over to Mark, and thank you all for joining us.
Greetings all. This is Mark Comstock. I'm your erstwhile leader, I guess, for this work group. Let me just say this work group started meeting back in, I think, May of 2019 for the remote notarization uniform laws. At that time, we were not contemplating electronic wills and attestation by remote means. Those are items that are coming up for the probate modernization work group that is meeting later this week a little bit, I guess. And we're working on that. We're trying to, in these interesting times, get a way to have remote notarization get before the, become useful in Oregon for documents because it certainly it's part of estate planning, but it's also part of a lot of transactions that are, let's say, hanging fire at this point in time. I've got two of them right now that are hanging fire, waiting for some way to notarize some documents. Let me just, I assume that Sandy, you have kind of a role of who all's here. So I don't know that we'll need to go through a roll call here, but I'll just say welcome, and you're certainly welcome to participate. Sandy sent out several emails that had attachments and documents to the emails. And what we're struggling with is we had draft legislation back in, approved in October of 2019 to go into the short session. We didn't have the ability to have a carrier in that short session. So it didn't happen then. Through the auspices of Senate Judiciary and Shanna Newell, who's on the phone, it looks like we will be part of a special session bill that is here. So that and what I want to suggest, if I can find it here, it's identified as LC 0029 draft something, draft 20 something. And if you want to look at that, page 28 is where the notarial acts part of that legislation comes in. And it is sitting out there pending when the call for a special session will be issued out of the governor's office, and hopefully this notarial act legislation will be adopted. I want to just point out it does have a sunset provision that goes to, I think, June 2021. So if it works, it will need to come back before regular session to have full consideration and hopefully adoption as regular legislation. I wanted to first, we can go through that notarial acts provision, but I will tell you it's very similar to the bill that we proposed back in September and October of 2019. A few little tweaks, but not anything major. But obviously, since we don't have a call for a special session right now, we're looking to see if there is a way that we can get this remote notarial acts to be useful by potentially an executive order from the governor's office. And hopefully somebody more knowledgeable than I can talk about what the potentials are of an executive order. But at least my understanding of the concerns are that there's a question whether a direct statutory override can occur from an executive order, and we're bootstrapping on some emergency powers of the governor, and Sandy sent out earlier today the links to those provisions. I think that just to focus in on what we're trying to do here is we need to figure out how we can either define by statute or enable the Secretary of State in a rulemaking provision to define what personal appearance means for ORS 194-235. And it's a short statute. I'll just read it to you. If a notarial act relates to a statement made in or a signature executed on a record, the individual making the statement or executing the signature shall appear personally before the notarial officer. And the draft legislation provides in section 48 sub 2 that a remotely located individual may comply with ORS 194-235 by using communication technology to appear before a notary public. We've got some ambiguity here. That is to appear personally. And if we can figure out a way to define that potentially through Secretary of State's rulemaking, that may give the ability to have this legislation come about, or at least an executive order with this legislation to come about pretty quickly. So you've also got a draft of the Secretary of State draft rules, and people more knowledgeable than I have commented on that. So I guess we're gonna go through that a little bit more. But I'm gonna open it up to folks that are more knowledgeable than I to see how we can get to earlier quick action on executive action. Don't all unmute yourself at once.
I wonder, this is Sandy. PK, I wonder if you wanted to chime in about what, if there's any, I know there's some folks who are joining us who might be interested in both the expertise in this group, in what their thoughts are about an executive order and the best way that we could do it.
Sure, Sandy. Hi, I'm PK Runkles Pearson. I'm the Oregon Law Commission Chair, and I'm here not as a subject matter expert at all, but just to assist the group in trying to bring this before the governor's office. I think that there are a couple of things that it would be helpful to hear from this group. The first one is, I think that in order to properly present the possibility of an executive order to the governor's office, I think that we would need to be able to demonstrate that there is some sort of immediate need now, and that the need for something before a legislative session is really important. And so to the extent that there are those of you here or elsewhere who can help establish that, that showing, I think that that would be very useful, because of course the governor would not want to take action on something if it could be easily done by the legislature later on. And my understanding, and folks please correct me if this is incorrect, is that the current statute does not define personal appearance, and personal appearance is currently defined to include actually being physically present by Secretary of State rulemaking. And so making this change would require, I believe, a change in the Secretary of State rules. So it would be helpful to talk about what the content of an executive order that we would be requesting would be. Would it be an order that would actually lay out our bill, or the requirements for the bill, or could it be accomplished more simply by establishing what the goal is and then delegating to the Secretary of State's office what to do in terms of enacting new rules. One final wrinkle that we ought to consider, I think, is what the effect would be of an executive order followed by later legislative action. If there was executive order and then later the legislature would take up our bill, which I believe that would be the proper way to do it, would there be any concern about interfering, for example, with vested rights that had already been created or changed in some way by an executive order? So those are the points that I think it would be important for the commission to know in terms of bringing this forward to the to the governor's office. And so we really need to turn to you as the subject matter experts to opine on those points so that we have something to move forward with.
Well, I guess that I'm going to jump in since there's silence out there. I'm looking at defining that personal appearance and seeing if we can use that definition for the draft rules and maybe define personal appearance to include appearance by simultaneous audiovisual appearance before the notary after all of the identity proofing has been done. And I looked at the draft rules and I was looking at OAR, Secretary of State's Rule 160.100.0850. And I don't remember what page that's on, but that I think would, let's see.
Mark?
Yep.
I I kind of have a preliminary question. I'm a Johnny come lately to this thing, so I'm sorry. But in regards to an executive order or promulgating rules, has anybody discussed with representatives of the county clerks whether they're going to honor that kind of action?
Well, I can't say specifically that anybody has reached out to the county clerks about the effect of an executive order, so that one is something that just came up this week. We have had people from clerk's office as part of this work group, and we believe that the county clerks are on board with the remote notarization concept, but
okay.
The executive order aspect is not something that we've run by unless we've got a representative from the county clerks on the phone today. I'd certainly like to hear.
So
this is Michael O'Neill from First American. I apologize for jumping in. Are we talking primarily about suspending or redefining personal appearance in the rules or under the statute? Because I think there would be a real problem if the governor's authority does not include suspending the operation of statutory law. And I say that because Oregon has enacted Rule ONA, which is a uniform law with the personal appearance requirement that you read off, that Rule ONA Section 7. The issue is that when Rule ONA was adopted and the official comments to Rule ONA make very clear that that does not include video conference technology. The official comments to Rule ONA say that personal appearance does not include appearance by video technology, even if the video is live or synchronous, nor does it include appearance by audio technology such as by telephone. And so, those official comments have been, interpreted, and a personal appearance has been interpreted the same way, essentially for centuries up until remote notarization was adopted. And it was the statutory changes in Rule ONA 2018 which changed that definition. So I think there would be a sort of a critical missing step if all we're talking about is a rules change and not something which the governor has, where the governor has suspended the operation of statutory law, which is the basis for many of the executive orders we've seen in other states. So I just want to throw that out there to make sure that we're all kind of on the same page about the moving parts.
And thank you. I've been probably keying on the Colorado executive order, which does recognize those two aspects. First, there's a temporary suspension of the requirement that the individual making the statement or executing the signature appear personally before a notary officer. Then it is the authorization to have the Secretary of State promulgate rules to authorize remote notarization. I don't know if Sandy sent that out. I assume he did.
Oh. The rules were, Mark, a couple things have come up. First, I want to give Ruth from Secretary of State a chance to comment. But really quick, I did get a message. I know that Rochelle, who's the Klamath County clerk, is listening, and they are aware of the issues that Rick Mills was talking about. But Ruth, I'll give the floor to you.
Yeah, just a couple of clarifications. So again, this is Ruth from the Corporation Division. I'm the Division Director. So the personal appearance requirement is actually in statute. It's in ORS 194.235. And so those of you who have been looking at rules that we sent out for comment, those are rules that were based on legislation drafted for consideration, not the existing rules. So the existing rules you can find through the Secretary of State's Archives division, but those rules don't contain a definition of personal appearance because it already exists in statute. So we don't repeat it in the rules. So we don't have the ability to change that just by rule. If we did, we might have already taken that option. And then I also just want to clarify for those of you that follow Rulona versus Rulona 2018, we did adopt Rulona, but it was a few years ago before Ron was part of Rulona, which is one of the reasons Ron was considered by the Oregon Law Commission. So I don't know, Sandy, you'll have to tell me if that was a good statement, or Mark.
Sandy, go ahead. Okay. Well, what I was looking at is on the, I think they are the proposed rules that were sent out. And I referred to 160, 100, 850. And that's on page 31, I think. And that has a heading that says audio and video quality requirements for remote online notarization. My concept is that, and I'm not quite sure what the sub 7 says. It says a remote online notarization operating model should, and then colon, this lowercase a, consist of reliable, continuous, synchronous audio and visual, so on and so forth. And then a sub B, if we define personally appear to be compliant with the subset requirements, is that a way to have the Secretary of State rules define or interpret the statute?
Can you say your question again? Sorry.
Well, in this requirements, the quality requirements, we've got a sub A and a sub B in 7. And if we define that the remote appearance complies with those standards, those A and B standards, is that sufficient interpretation of personally appear for rulemaking?
No.
Okay.
The issue at the heart of this seems to be ORS 194.235.
Correct.
And so it would have to be a statement. My guess is that it would have to be a statement from the governor that says the personal appearance requirement in that statute would be satisfied by a remote online notarization in conformance with rules issued by Secretary of State or something along those lines. So we can get to the details of it in rules, but we'd have to, that's a piece we can't do.
Okay.
I guess.
And this is Michael O'Neill again. I just want to point out that Sandy sent around the governor's powers in an emergency. And just to reiterate the point, the Colorado emergency order that we've seen was based specifically on the Colorado governor's authority to suspend any regulatory statute that affects the conduct of state business. And that's the type of authority that most other governors have relied on. So I think we would want to see that type of similar ability to suspend statutory law that the governor in Oregon could exercise.
My question would be whether the authority in 194.360 that authorizes the Secretary to adopt rules implementing the chapter and including rules prescribing the manner of performing notarial acts regarding tangible and electronic records, would that grant the Secretary of State the authority to issue a rule that interprets what constitutes a personal appearance, such that a personal appearance could include appearance by electronic means?
Hal, what was the statute that you were referring to at the start?
It's 194.360.
Okay.
Ruth, this is Sandy. Did you have an opinion on that regarding Secretary of State, or?
I didn't actually hear the whole question, so
Okay.
I'm looking at what was the first part of your question there, or your statement there?
So this statute grants the Secretary of State rulemaking authority with respect to notary issues. And the rulemaking authority includes rules prescribing the manner of performing notarial acts, whatever that means, regarding tangible and electronic records. And is it possible that that rulemaking authority is broad enough to interpret the phrase personal appearance or appear personally, such that you could say personal appearance includes personal appearance through electronic means?
No, I don't think we can, because 194.235 clearly states what a personal appearance is.
This is Sandy. I
And
did
that's
want to
perfectly consistent with how Rulona 2010 operates. That rulemaking authority extends to things like using tamper seals on documents, and it doesn't relate to the personal appearance requirement, which again, the official comments, as well as the more than a century of case law backing up what the personal appearance means, expressly rules out remote appearance under the statute.
And I guess that's the question, is if we have something in our legislative history similar to what's there for the Uniform Commercial Code that says the official comments to Rulona are essentially part of the legislative history and express the legislature's intent, then that would seem to say we're dead in the water and there's nothing we can do without legislative action. And that would be the only thing that we can move forward with. But if we don't have that, then I might ask, well, 194.235 just says shall appear personally, but it doesn't say exactly what that means. And there I might then say, well, is it reasonable to have the Secretary of State interpret that statute in a way that says personal appearance can include electronic appearance? And if we can't get there, then nothing that we're talking about is going to matter other than legislative action.
Yeah, Hal, this is Sandy. I was kind of on the same page. Based off of, and I know that Michael, who has been looking through, he sent me by email the governor's rules in Oregon. But I think hopefully there's some folks on this call who have more expertise on how the governor's rules during an emergency can be applied potentially to allow an emergency, a executive order for this. And I think I think we need to clear that issue before we can get into anything else. So I'm just curious if anyone on the call has any thoughts about their expertise on how we can make the arrangement potentially so that the governor could potentially issue an executive order that would not be in violation of everything that was just discussed by Hal and Michael.
So this is Rob Bovett. I'm currently the lawyer and lobbyist for the County Clerks Association, and maybe this is an okay time for me to chime in.
Sure.
So first, a couple of caveats. One is I don't represent any individual county clerk as a lawyer or a lobbyist. They each have their own county attorney, so you have to take that into account for everything I say from here on. I have been working with the governor's office on executive orders, including one we're working on right now, to essentially extend critical timelines and allow for things in terms of hearings and other such things that I won't bore you with, that we need relief from so we can comply with her social distancing mandates. I think the rub here is that lawyers that have looked at our provisions related to emergency declarations in ORS Chapter 401 and encourage folks to have a look at those. It's not real long and it's not real dense, but I think especially the lawyers on this call will probably recognize that the statutes there aren't written as cleanly as we'd like. It would be lovely to have something specifically state outright the governor has plenary authority to essentially suspend any particular statute, but that's not quite how it reads, and we have a variety of legal opinions on that issue. But even if we could, say, get across a bridge and get the governor to enter an executive order kind of suspending the provision of that one particular short statute that requires the personal appearance, and even if we could get a county counsel who represents a county clerk to advise that that's effective and a recordable document, I guess my real question goes back to where it really kind of matters in a way, which is, what do the title companies think? What do their counsel for the title companies think about 401? And will they acknowledge and recognize the governor's authority to suspend that statute? And so I don't mean to kick it off to somebody else, but really, if title companies aren't going to insure title off of, doing remote notarization like we're proposing and really kind of needing to do right now, then all the rest of our conversation is kind of dead air, in my opinion.
Thanks, Rob. Cleve, are you out there?
Yes, Mark, thanks. Well, I think that I haven't had much of a chance to look at the governor's authority under an emergency, but it appeared to me that if she has authority to modify or the status of statutes, that it needs to be within the realm of her police power, and I'm not sure notarization rises to the level of police power, and certainly there may be some folks who understand or are more familiar with those statutes who would come to a different conclusion, but I think that gives us some concern. If it's beyond the governor's authority, then are all the deeds that are notarized this way during the period of the emergency, are they subject to attack or challenge? And that's the kind of thing that title companies are going to be would be very concerned about. We I think rely on for us to move forward with remote notarization. We've gone down that road with the work group, and I think it was kind of taken for granted that the personal appearance requirement did need to change, and that meant a statutory change. And of course, we worked on developing statutes that would have that effect, and draft rules are also premised on that statutory change.
I know that PK has a comment that she'd like to bring up.
I guess what I would say is that I don't think that this group is going to be able to determine during the course of this call what the governor's authority is. But what I think would be helpful is for us to be able to tell the governor what it would require in order to make the change that we would be requesting. And then, the governor and her counsel could determine whether or not they believe that that is within her powers or not. So I think the question that would be most helpful to know is, does it require a change in the statute to do remote notarization, or does it simply require a change in the rules?
This is Ruth. It requires a change in the statute.
And Ruth, what is that based on? Because for me, as a non-practitioner in this area, looking at the statute, I think others have raised this as well. There is no definition of personal appearance in the statute itself. So is there something else that we're missing?
No, no.
To me,
and I will point out it is the common law definition of personal appearance. So Rulona uses many common law concepts such as acknowledgement, credible witness, etc. And when it pulls over these common law phrases and terms into statutory text, the assumption is that it is adopting the common law definitions unless it is changing the common law. And then when it changes it, that changes traditionally, narrowly construed, strictly construed against change. And so that's the general way that you look at notary statutes and Rulona specifically.
So let me just ask maybe a pedantic question here. What is different from a simultaneous audiovisual appearance before a notary from physically being in the present? Is it the smell? What is it? I'm trying to figure out why we can't define personally appear to include the simultaneous audio-visual if in fact all of the aspects of a physical appearance are available to the notary.
Mark, I don't know of anything that interprets, this is Heather Gilmore, I don't know of anything that interprets physical appearance in notarial law, but certainly there's a great deal of both Oregon and nationwide common law that talks about personal appearance in the context of witnesses to wills. And it means physically present in the same room. So I don't know whether those same terms would transfer over from will execution and witnessing to notarial acts, but we certainly have a good body of case law that supports that concept of physically present in the same room.
Well, and I agree, Heather, that attestation and will witnessing is more closely defined in statute, but I'm trying to see if there's a hook that we can make some kind of differentiation for the purposes of personal appearance on the notary side.
I think it all boils back down to this question of statutory interpretation. And if there is a plausible interpretation of 194-235 that would go just the way that you just said, Mark, that could be upheld in Oregon law, then I think we could get there. And it would, I mean, it seems to me that the optimal way to get there would be through Secretary of State's action, because that's specifically authorized in the statute. And maybe the governor has the power, maybe the governor doesn't, but clearly the Secretary of State has the power to issue regulations to administer this. But if we look at the principles of statutory interpretation that apply in Oregon, and I forget the PGE case and all of those rules that you start to work through, it comes back down to this issue of, okay, what did the legislature intend? And is it reasonable for the Secretary of State or the governor to interpret the statute in this way that we can appear electronically instead of physically? And if that's not reasonable, then down to the question of, number one, is there, oh, go ahead.
No, you go ahead.
Is there legislative history from when this was adopted originally that references those official comments? And if there is, then I think we've got a problem. But I don't know the answer to that.
And I don't know the answer either, whether in fact it was an Oregon Law Commission.
It was.
Proposal. It was. Do you have the?
Well, Rulona was back in 2013.
Yeah.
So that means that yes, I could access it. It would take a little bit of time to find it, but I will be able to access that.
Okay. I've been looking at ORS 401-168, and that seems to circumscribe the governor's powers over only executive agencies and to suspend any order or rule of a state agency. But I don't see anything about being able to suspend a statute. Is that where the rubber meets the road on this one?
Hey, Mark, this is Pat Inett. I think that's exactly it. And that was Cleve's point, is that 401.168 doesn't appear to give the governor authority to suspend or change the statutory requirements. So the only other option is police power, and the likelihood that this would fall under a police power issue is not there in our minds.
Okay. Pat, thanks. What, in your mind, would it take to fall within a police power if it is not the avoidance of pandemic?
Well, that's a good question. We were originally looking for the statutory fix because so far we're finding that there are other ways to notarize, including the notary issue that I think Ruth said that the Secretary of State has sought guidance on from DOJ, and that is remote online notarization by a notary in a state that already has RON. And the county clerks in Oregon, probably all that we've canvassed have said that they agree that under Chapter 194, if the notarization is performed remotely by a notary in a state where RON is already enacted and implemented, those are acceptable records for recording purposes. And that's been the alternative that we're using currently for those folks where there's an absolute emergency. In other situations, precautions are being taken to avoid exposure. I mean, very creative precautions, talking through a window and then sliding documents through the mail slot for people who are diagnosed and ill and sitting at home in quarantine. Customers who don't want to interact in a branch office, we're doing drive-ins. And same thing, they drive in, they park, they tell us we're there. They've already reviewed all the documents online, talked over the telephone, and they sign the 1 or 2 documents that require notarization and hand them through the crack in a car window. Or they stand 8 feet apart from, one party on the hood of the car and the other party on the trunk of the car. I mean, there is all kind of creative activity going on here to avoid exposure. And I agree with Michael that absent a statutory fix, it didn't appear to us that the governor had the power to make that change to 194-235. But, of course, I defer to people who know more about police power.
Well, in kind of light of this conversation is, well, if anybody has a different thought, I'm kind of looking at, it doesn't look like we can get to an executive order because we don't have statutory authority in the governor's office to get there. Does anybody differ with that?
Mark, I don't know if it changes anything, but Shanna did suggest that the group look at ORS 401.192, which is the section that deals with emergency power during emergencies, whether that would be something different to take a look at.
Okay.
Well, Mark, I think the thing ultimately boils down to is the ultimate arbiter on these questions is going to end up being the Oregon Supreme Court. And does anybody want to gamble on an important transaction, such as a real property sale, where we can't 100% predict how the appellate courts are going to rule?
And of course, that is, the parties are really the final decision on risk taking. So,
Mark, in favor of your position is ORS 401.192, paren 1.
no, hold on, I haven't got there yet. But.
So for people who need me to say that again, it's ORS 401.192, paren 1. So I think the first phrase of that paragraph means the rules and orders are equivalent to statute, but that's not my area of practice. So I'm saying that's what I think it means, but feel free to disagree with me or educate me differently.
This is Marisa. I wouldn't take that to mean that the emergency orders can supersede statute.
So Marisa, a true question. What does it mean when it says all existing laws, ordinances, rules, and orders inconsistent shall be inoperative?
I don't know. I haven't researched it personally, but I don't know. I mean, probably the governor's office knows more about what they think that means than me.
I agree. I just think it's a really good question. Like I mean, if the order can supersede the law, maybe we do have authority. I don't know. I don't know enough about executive powers in the state government.
Well, and of course, it may take delving into 401.192, the history of it. And certainly that does look like a hook, but is it?
So this is, oh, I'm sorry, Mark.
No, go ahead. Have at it.
What I was going to say is it just seems, I think that everyone is doing a great job of searching for potential ways that this might become an executive order. But I think that I'm just curious, we can talk about the emergency action otherwise, but it does seem, does anyone else who hasn't had the opportunity to speak have any differing opinions about whether or not if you know, the goal in the meeting today was to have a conversation about whether this idea was worthy of drafting and pursuing as a executive action. It sounds like there are a lot of hurdles. It sounds like a lot of those hurdles are actually going to be interpreted by the governor's office and the governor's attorneys in the end. But I'm just curious if, and Mark, I didn't mean to cut you off if you're getting into one, but just to kind of get folks in line, if there are any ideas that have not been brought up about specifically, you know, what avenues could potentially be there, or if the group consensus, I just don't want to waste anyone else's time, is that we need to continue to stand behind the legislation which we put together.
Well, I'll jump into that and say, from the discussion here, it does not appear that an executive order would have, let's say, positive effect with the people that need to make decisions on transactions and ultimately probably court determinations. So I'm thinking that an executive action may not be a way that we can get there, because we can't get around 194-235 and the personal appearance wording of that statute. I think we're just we're admiring the problem a lot, but I don't think we're getting to a way that we can plausibly convince the governor's office that there is anything other than a statutory change that needs to happen. Somebody argue with me. Hearing no argument. Oh, there I got something.
So I'm sorry, and I'm not a member of this committee, I'm just observing, but I just had a question, and feel free to educate me that I'm incorrect here. But to bring it back to isn't what we're concerned about the definition of personal appearance in 194-235? That's,
I think, the key part, yes.
Okay, so since personal appearance is not a defined term, isn't that traditionally within the discretion of either the governor or the administrative agency to promulgate a rule interpreting that?
Well, that's where I started. That's where I started, yeah. Yes.
Outside of the scope of any statutory change. What I'm hearing people say, and perhaps I'm incorrect here, but what I'm hearing people say is that we need a statutory change. And I don't know that there's a statute that needs to be changed so much as a definition that needs to be expanded upon. Does that make sense?
Yeah, that makes sense.
Okay, so why I don't think that 401 is particularly I don't think 401 is implicated by that. I think, to the extent that there is a rule, perhaps if there were a rule that needed to be superseded, then 401 192 sub 1 would certainly come into play, right? Because you'd be superseding an existing definition of what a personal appearance is. But here we don't have an existing definition of personal appearance, unless there's something that I'm missing, which is possible.
Val, I think the issue is that there are limits on what the Secretary of State can do under the state equivalent of the federal Chevron case, and what are the limits and the scope of a state agency's authority to interpret the statute, and that gets back to the comments. I forget who it was that made them at the beginning of what was a part of Rulona, and as well as all the common law and the cases that have been shared in the chat already, where if it were clear to the court that that this phrase, when this statute was adopted by the legislature, was intended to mean physically appear as opposed to something more vague than that, then it's not within the Secretary of State's authority to define that phrase to include electronic appearance. I'm not necessarily letting go of the idea that might not be possible, but from what I've heard, it sounds like those official comments are going to be part of the legislative history, and even if they're not, we got a whole bunch of common law that would be going against us on that particular issue, and that would make it awfully hard.
I'm sorry, Harold, you're cutting out at least on my feed.
Sorry, I was just saying that based on the common law that's been brought up already, and on the official comments to Rulona that likely are part of the legislative history, that if the Secretary of State did in fact issue a rule and someone challenged it, there's a good chance it might not be upheld. Because it's only within the Secretary of State's authority to interpret and apply the law. It's not within the Secretary of State's authority to change the law.
Right. So are you saying then that what would probably be necessary would be some sort of declaratory ruling action, saying that, you know, on an administrative procedure basis, saying that this would be consistent with that? That's what it would take to get people to a point of comfort. Because I know that a lot of the, I'm involved with the business law section, and we've been getting a lot of feedback today saying that we really need something like this, both for our real estate clients and for our estate planning folks. You know, and I understand the estate planning has a whole separate thing going on with the, you know, execution of those documents. But, you know, would that be what it would take to get to a point of comfort, is some sort of declaratory ruling saying, yes, Secretary of State does have the authority to implement this particular rule, or, you know, implement this definition?
I think by the time we got there, ideally, we'd already have the statute from this special legislative session.
Perhaps.
Well,
this is Sandy. I did do a little bit of digging based off the fact that Rulona was an Oregon Law Commission bill. I put it in the chat there, as expected, in the legislative history, which is the report of the Oregon Law Commission. It does very specifically say that appearance by webcam does not meet the presence requirement.
Well, that pretty much puts a nail in the coffin here. So I guess I'm still back to, I think we need to put our efforts in making sure that statutory provision gets teed up and going forward.
Hey, Mark, this is PK.
Yep.
I wonder, you know, not all practitioners have the benefit of being present in this meeting and hearing this discussion. And I wonder if there might be something that this group could do to disseminate some guidance about appropriate ways to get things notarized between now and any potential legislative session. You know, the comment about things coming through the window is, I think, very helpful. And I think people would appreciate knowing that.
Okay. Is there anybody who wants to volunteer to suggest how to get notarized? Sandy, you raise your hand.
So Mark, well, I know that Ruth and I had already had a discussion. Ruth, do you want to chime in?
Sure. Yeah. We've kind of been waiting on issuing guidance in the hope that there might be some gem of a, you know, or some glimmer of hope in an EO that would advance Ron, at least temporarily. But there has been really good information already put out there by NASS and some of the other notary organizations, and we can compile all of that that's legal in Oregon and issue formalized guidance to notaries. And we have a couple of vehicles through which we could do that, but I'd be happy to share that with you, Sandy, so that you can get it out to kind of bar contacts in addition to OLC.
And Ruth, one thing that I can help to facilitate is if you, getting that draft out and then ensuring that before it's published, that members of this group will have an opportunity to provide comment. That is, you know, between the estate planning bar and the elder law bar and folks who are a part of who we reach out to with this particular work group. That's been very helpful with the rulemaking process for Ruth, and I'm happy to help facilitate that. So once that guide comes out, if there are ideas for that, I can help facilitate that communication.
Anybody want to jump in on discussing the draft rules? we kind of went over that agenda item, or is everyone kind of given their comments to them?
So let me jump in. This is Ruth from Corporation. We've received some very good comments. Some of them we were able to make kind of immediate changes, or there were little mistakes or typos that we needed to take care of, spacing issues. But there's a couple of issues that are a little bit more complex that we're going to start working on tomorrow, so that we're ready for whatever comes and whenever it comes. And then as soon as we have a new draft, because the trickle of suggested changes to the rules has sort of dropped off in the past few days. And so once we're sure we've got everything, then we'll send a new version out to Sandy and Mark, so you guys can get it to the Ron work group. And then if there are any additional changes, we can go from there. But we do want to make sure that we're as ready as we can be. So we've been working on the other elements that would be necessary to have in place if there were legislation passed, or if there were an EO put in place that would allow Ron notarizations, and that, you know, includes things like education and website information, standards, lists of the, you know, platforms that meet technical standards, that sort of thing.
Okay, well, thanks, Ruth. When do you think you're going to be kind of finalizing your thoughts on that, the redraft?
I'm hopeful we can have that done by Thursday.
Okay, great. That's certainly timely.
Yes, may I make a comment? This is Tim Reiniger.
Yeah.
And I think Michael O'Neill, if he's on the call, might shoot me for saying this, but I do want to bring up, it was mentioned about the estate bar. So certainly in this emergency, I've been in many discussions now with issues of healthcare providers wanting immediate assistance with living wills, updating wills, writing wills, or elderly folks who are afraid of getting sick and realizing they want to make changes. And so there's a lot of panic going on in the estate end. And now, as we all know, the UEDA law, the e-sign laws expressly carve out wills, codicils, testamentary trusts from the use of electronic signatures and records. Just like 4 or so states have authorized electronic wills. Now I'm bringing this up because I think what we're going to see, though, is the estate lawyers and others, as this goes on, will still want to use remote, but with paper forms. So when we talk about remote online notarization, driven by the real estate use cases and sectors, everyone thought from the beginning the logic would be full electronic documents, full electronic notarization for that process. Now we could be looking at a huge use case for a sector that may want the ability for just a remote notarization and still using paper documents, but they have the 2 witness requirements and so forth. So I bring this up because going forward, it may be worth looking at the future laws and rules, because I think the rules are going to be probably at this point mainly geared towards the assumption of electronic documents as being the big use case. There may not be need for many changes, but I'm just pointing this out as something to consider going forward. So, the needs of the estate lawyers will be a little bit different from the real estate use case.
And Tim, thanks, because that dovetails into another work group that is meeting this week that will be tackling just kind of that issue of how there can be potentially remote attestation or remote witnessing, and how that could work. So not passing the buck because I'm kind of on that same work group, but that's we're looking at it. Well, if we've admired this problem fully and kind of reached a conclusion that we might not get there at the moment unless somebody has a bright idea, and certainly the emails work. Is there anything else that we need to talk about for this afternoon?
Mark, this is Sandy. I did want to bring up, because not everyone can read the comments. Ruth did in the comments was just wanted to put the call out that if anyone has ideas or case studies on how to conduct traditional or electronic notarizations safely for all parties during the current crisis, to send those to Ruth. And if you don't have Ruth's email, it's ruth.miles, M-I-L-E-S, @oregon.gov.
Okay. Thanks all. Off to your other sunny activities this afternoon.
Mark.
Bye.
That's Cleve.
Yep.
You have something?
Cleve?
Yeah, I was just saying thank you to Mark.
Oh, okay.
Oh, yes.
Thanks.
Thank you, everybody. Thank you, everybody, for joining us. I think the conversation was really important. And if we have other things to bring up and call other meetings, thank you all for being so responsive, and hopefully we'll talk to you soon. As there are updates on the legislation front, I will also keep this group updated. Thank you all.
Thanks.
Thanks.